Hi there, everyone. My name is Kelly Jackson. I'm the executive director here at NAMI Johnson County, and I am really excited for today's workshop. I've got Christine Deibler here. She is the manager of quality and integrity with Johnson County Mental Health, and she is here to teach a very important topic for us, which is guardianship, power of attorney, durable power of attorney, and advanced directives. Great questions that we get often at NAMI, and I'm just really excited to have a local person come and share her wisdom and her knowledge on this topic. And so I'm going to let you take it away, Christine. Thanks for being here.
All right. Thank you, Kelly. Hi, everyone. It's nice to meet you, and I'm so honored to have the opportunity to share a little bit of experience, strength, and hope in the topic of guardianships, POAs, DPOAs, and advanced directives. Oh my, what a big topic. But before we dive into that, I do have to have a disclaimer shared with you. First of all, I am not an attorney. I'm a licensed master level social work, have been for almost 25 years. So the information I'm sharing with you is based on my lived experience as a mom of two adult children, as well as a professional working at a community mental health center. So please do not consider anything I share with you as legal advice. Rather, I would recommend as after this is done and you have questions of the legal nature, I'll provide some resources that I would encourage you to reach out and seek outside counsel if ever needed. So again, I'm a social worker, not an attorney. So let's dive in. Guardianship. So, guardianship, what is it and how might it help with my family members' needs? I think it's most important to denote that guardianship is a legal appointment to an individual to make decisions on behalf of a vulnerable person, or in this case, they're referred to as a ward. Guardianship is a vital legal mechanism that protects and supports individuals who are unable to manage their own affairs. Now, whether that is a minor, that is an adult with disabilities, an adult with serious mental illness or substance use issues, or an elderly individual, this provides structure to ensure that they're well cared for and their needs are being met. So it's important to understand the different types of guardianship, the process by which one is appointed, so that families and caregivers can make good decisions about the need for guardianship. And I'm also going to talk about some other things that might be used in lieu of a guardianship. So let's dive into the types. The first type I want to talk about is temporary, and this is one I see a lot at the mental health center first. And typically, this will come about in response to an emergency or immediate danger of an individual. These are typically short in duration. Sometimes they're only appointed for about 30 days. And in this case, that can include a guardianship or conservatorship. So those are two big terms. How about if I break that down before we go further into the types? Conservatorship typically deals with the financial needs of a ward, and that would be to purchase property, sell property, manage their finances, procure the stocks and bonds or selling of things, managing their bank account. That kind of stuff is typically referred to under a conservatorship. Guardianship typically covers other affairs like housing, education, daily living needs, healthcare decisions. But it is possible that in a guardianship situation, the guardianship papers discuss financial and other affair needs. So after a temporary type of guardianship, there's also a limited guardianship and or conservatorship. And typically these are restricted to specific types of areas. For example, limited guardianship for medical decisions, limited conservatorship for financial affairs. The next type of guardianship, conservatorship, is considered a full or plenary. Plenary. It's a tough word for me to say this late in the day. And that would be a situation in which an individual is appointed guardianship and conservatorship. So it handles both those activities of daily living and those kind of needs, as well as financial pieces. And then a fourth type of guardianship, and this is sometimes rolled into the full guardianship, is standby guardianship. And that's basically an appointment for a designated person who's going to assume the role of a guardian if for some reason the current guardian is unable to serve. For example, if I am a guardian of an individual, an adult, a vulnerable adult. In the full guardianship conservatorship papers, there may be language that designates my spouse as the standby guardian if something should happen to me. And that's not unusual in some of the guardianship stuff that we see. And if it's not in there, it is recommended to provide for the continuity of care for that individual. So some of the roles and functions of a guardian, first and foremost, include, and I can't emphasize this enough, is honoring the ward's preferences as much as possible, unless, of course, there's a safety concern or risk of imminent harm that requires me as the guardian to make that tough legal decision on behalf of the individual. And I've got an example of that I'll come back to in a minute. The other role and function is, again, that making legal decisions for the ward and with their preferences in mind. But as the guardian, it's my decision about admission to hospital. It would be my decision about selling or purchasing property on behalf of the individual. It's that legal appointment that matters there. Another function is always to provide advocacy and support for the ward. It is really important that as a guardian that either is appointed by the court, because sometimes they can be appointed, or sometimes it is a family member, a trusted friend that gets that legal designation. But the whole purpose is to make sure the well-being and needs of that individual being met, and that is done by providing advocacy and a support to that individual. And another role or function for a guardian is to be mindful that there is a requirement to have an annual report submitted to the court each year after the temporary order has become full order or a limited order. So the process, honestly, is a little tedious, and I do believe that my experience of looking at some of the guardianship statutes in Kansas is there's a lot to it. And it is such an important role and function that while an individual doesn't need to have legal representation to file a petition for guardianship, I highly recommend it because there's just a whole lot of integral parts of the process that need to be respected, and as the guardian and or the ward need to be thought of as you enter that relationship. So I would say always start first with seeking legal counsel, and one of the best resources is the Kansas Guardianship Program. I later have some information about that on how you can access that information. But once the decision is made that this individual is no longer able to make decisions on their own behalf and needs that level of support, then the next step would be gathering the necessary documentation to assert that petition for the individual. And that may require getting releases of information to get documentation from the mental health center, a hospital that may have served that individual, banking institutions, landlords, things like that. Information that will help the court understand and be evidenced by this individual lacks capacity to make decisions on their own behalf. Once that information is gathered, the petition's filed, and the petition will include all of that information about being hospitalized at this place for this diagnosis, maybe include been evicted from this housing situation because of XYZ. All that information goes into the petition, and that is presented to the court. The court will then set a hearing, at which time the hearing will include the petitioner and potentially legal counsel. It'll also include the ward or the potential ward, who may also have counsel appointed to them. And then the information is presented to the judge, and then the judge makes the best decision based on the evidence or information that's presented to them. If the judge concurs that this individual lacks capacity, then what is appointed is a letter of guardianship, and it's in the form of a journal entry, and it's date stamped, and it should outline all the things the guardian can do. It oftentimes won't go into detail about what they can't, but they will probably refer to the statutes in Kansas that govern how guardianships are appointed and how they are maintained. And from that point, unless it's a temporary one, which would need to move to either be disaffectuated or unaffectuated or move to full guardianship, there's that time limit there you got to think about. At that point, then the guardian begins to manage the ward's affairs, and that can be some considerations about that can be that's going to be a pretty ominous charge. Some things to think about when entering or thinking about a guardianship relationship is there are costs associated with going through this process. At a minimum, there's court fees, and I can't tell you how much those are because those vary from county to county. There could also be attorney fees, and again, as I mentioned, it's not required, but I highly recommend going that route so that the best possible decisions can be made on your behalf as a potential guardian and the individual that you hope to be helping in the ward. In Kansas, just recently, as a matter of fact, just a few days ago, at the beginning of 2026, there's been some changes to some of the guardianship laws, and I'm going to go over some of those. One of the big tenets this year that is being underscored and valued is least restrictive environments and settings. So what that means is, by a layperson, is that if I'm the guardian of an individual, I have to pursue options that are least restrictive. While I may have concerns about their ability to care for themselves, it doesn't mean I can sign them into a hospital or a state of institution without due cause. And in some cases, is that really the least restrictive option for that individual? So always looking at least restrictive first. And then there's an increased oversight for guardians now. And the important thing to think about there is, and this isn't kind of not meant to be a scary thing, but it's just something that needs to be acknowledged, that as the guardian, I'm obligated to make legal decisions on that person's behalf. And failure on my part to do what's in that client or ward's best interest could result in a report to protective services for fraud or abuse of a vulnerable adult or a child. I think that the legislation now is just really trying to make sure that as we enter these legal binding relationships, that the guardian and the ward and their legal counsel all understand the importance and the weight and gravity of, in some cases for adults, removing their ability to make their own healthcare decisions. And so oversight is real important to ensure the well-being of all parties involved. And I mentioned the ward's voice. Again, finding out what their preferences are is really, really important. In Kansas, with this new legislation this year, there are some flexibility now of honoring or accepting outside state appointments. Each state has different guardianship laws, and if it doesn't necessarily mean in Kansas, if you're appointed as a guardian, if the individual moves to Missouri, that Missouri will honor that guardianship. Oftentimes, states will, and it's kind of at the provider's level to honor it or not. But it's just important to know these things vary state to state, and that is why I think it's real important to have outside counsel involved so that you know what you're walking into. So guardianship is like the top of the pinnacle in terms of legal action that one can take to help a family member that is struggling with making decisions. There's also a relationship that I'm going to refer to as power of attorney. And power of attorney, or POA, is a contractual agreement between two parties that allows the individual, the principal, to name someone on their behalf to handle their finances or healthcare decisions if the principal cannot. So, example would be myself as I have two adult children. I have a durable power of attorney. I'll come back to that. But I have power of attorney that they have given me permission on their behalf to carry out their affairs or their businesses. I don't make decisions for them. I honor what their requests are. And it just occurred to me that I got so busy talking about power of attorney, I wanted to give an example of guardianship and some of the complexities around that. So if you'll indulge me for just a minute backing up there. I have a dear friend that is a guardian and for an adult in a nursing home facility and has been their guardian for a very long time. This individual that for whom they're a guardian has some pretty serious health ailments, and they're kind of getting to the end of life decisions. And one of the quandaries that my friend has is the guardian respecting the wishes of the ward weighed against what they believe and the healthcare providers believe to be a better decision. The case is this. The ward does not want to sign a do not resuscitate order. They're at the end of life. Healthcare providers and my friend who's the guardian respect that. However, understand that certain measures to life-sustaining measures may cause some pretty serious bodily harm to this very frail and older individual, and trying to work with them and understanding that if they make this decision, which everyone wants to respect and honor, the consequences there too. And I don't have an outcome to share on you on that, unfortunately. I can just tell you my friend has really been working with the ward and the healthcare providers so that they can come to a good decision for this individual. And it's something that is a very it's a heavy example, but one that I think underscores the gravity of being a guardian and honoring client or ward voice. So I'm sorry about that, messed that up. So I'm going to jump back over to power of attorney. Thanks for joining me on this journey. So powers of attorney, it's important to understand difference between this and the legal guardianship is this typically isn't a court appointed situation. This is an agreement between two individuals for someone to make decisions, follow through their decisions on their behalf if they're not around. Want to talk about the types of powers of attorneys in Kansas. I mentioned durable power of attorney. I'm going to come back to that because I'm going to talk a little bit more about that in detail later. But in general, there is one called general powers of attorney. And this would be an individual that has been given the opportunity to follow through with someone else's affairs, physical, housing, educational, whatever. But under general power of attorney, if that principal or the person that gives me the permission as their POA becomes incapacitated or dies, the power of attorney ceases to be effectuated. It's no longer a valid POA. So those powers of a power of attorney only are acting as long as the individual is still of sound mind to make decisions on their behalf. Other types of POAs include a limited or special, and those are typically for specific purposes like selling property or procuring some equipment or something of that nature. There's also a medical or healthcare proxy power of attorney. Those are typically done in hospital settings when someone comes in and they don't have an advanced directive, they don't have medical POAs yet set up. And this is the process to help them get that done, and see it a lot done in a hospital setting. There's also parental powers of attorney for those individuals that have minors, if maybe they're traveling out of town or it's maybe a soldier going off on deployment. Parental POA allows this other individual to care for the minor in their absence. The last two types of POAs are typically more around someone doing taxes for another person. So if your accountant does your taxes or an attorney does your taxes, you're probably signing a power of attorney so that they can submit that on your behalf. Certainly, if you sell a car in Kansas, you may sign a vehicle power of attorney that allows the dealership to sell the car in your absence. Those are some of the different types of POAs. And now POAs do have some requirements around them. First of all, they need to be in writing and they must be dated. There's also a requirement for signatures of the principal, which is the person giving the permission to the agent or the power of attorney, the effectuating powers. And in some cases, witnesses are required, particularly for medical POAs. They usually almost require two witnesses that are not related to the individual. Some providers, some entities also may require a notarization. That's just an important distinction to note that, particularly in hospital settings, I think they typically prefer those to be notarized. And then there may be a requirement to have specific language. For example, if it's a limited or special, type of POA, that needs to be spelled out pretty clearly in the written document. Now, it's important to note that POAs allow the agent to manage affairs on behalf of the principal. It does not allow them to make legal decisions after the individual has died, unless, of course, that POA is a legal representative or the next of kin. That changes upon death. It does not allow the agent to act in a manner inconsistent with the principal's practices. For example, I brought up my kids and having a DPOA for them. I can't make decisions that they don't agree with. As their mother, sometimes I want to do that, but as their DPOA, if they want to bank with a specific institution and that's where they go, then that's the business I help them with. If they are needing assistance with healthcare, I make appointments or follow up with providers in their absence for the providers that they have chosen. And again, I got to underscore the gravity of this type of relationship because the misuse of that power can also result in a report to protective services. So durable power of attorney, I mentioned that early on when we started talking about powers of attorney. The difference with a DPOA or durable power of attorney and a POA or power of attorney is a DPOA still remains in effect if the individual becomes incapacitated mentally or physically. So in some cases, and I speak of this with my children, this having the DPOA for both of them allows me to, at that point, to make decisions that are consistent with their wishes. If for some reason they are unable to do that and speak their wishes themselves, they're in a car accident, if they become, if they have a mental illness and they decompensate, we've already agreed to what things they want to have done. If that happens, a DPOA allows me to kind of spring into action on their behalf. And again, a DPOA can cover finances, healthcare, or both. And typically a termination for a durable power of attorney is pretty much at the principal's pleasure. If my kids at some point go, Mom, got this, don't need you, don't want this DPOA, then that's when it terminates. It also terminates at death or date of expiration. In some cases, some people have dates on the POA or DPOA that says, I'm going to be able to act on this for this individual for this period of time, and after which time this agreement is no longer valid. But it's important to denote that powers of attorney, whether it's a POA or a DPOA, are kind of deactivated in the same manner by which they're effectuated. What does that mean? So what that means is if it's written, signed by a witness, signed and witnessed and notarized, to deactivate it, the revocation needs to be signed by the principal. The agent is not required. It needs to be witnessed and it needs to be notarized. I don't have any really good resource to give you on why that is. I just know that's information that we've received from legal counsel here at the Mental Health Center. So that's what I share with folks. Now, one of the things that makes the DPOA kind of a cool option, I think, is it allows for continuity. It ensures that someone is on that individual's behalf is trusted to manage affairs during their illness, accidents, or absence. So in some cases, it may help avoid the need for guardianship, and one for healthcare that it makes some good sense for some folks, I think, to think about as an option. There are some limitations. Again, we talked a little bit about this, but an agent cannot create, amend, or revoke a will. If the principal or the individual has a will set up, it is what it is. The agent or the DPOA can't modify or change the DPOA unless they're terminating themselves as an agent. I'll go back to my kids as an example. My kids can revoke that, but I can't change or modify the DPOA unless I'm saying, hey kids, I can't do this anymore. You're going to either have to figure this out on your own or find another person to be your agent. But otherwise, the agent doesn't make any modifications or changes to the DPOA. The agent cannot execute or revoke a DNR. And I'm going to talk about DNRs a little bit in the advanced directives here in a minute. The agent may not make decisions on the principals after the principal has passed away, unless, of course, they're that representative or next of kin. And they can't take any action that fails to follow the principal's wishes. And I've said that multiple times. And again, it's about that understanding either the ward or the principal's wishes so that we can together make good decisions. DPOAs do require it to be a written document and it must indicate it is durable. If the D word's not there, it's a POA and it may cease upon incapacitation. And the principal and the agent must be of sound mind. And of course, there's the requirements for signature, witnesses, notarization, et cetera. Those are all pretty similar. Now I'm going to talk about advanced directives for medical or psychiatric. There are advanced directives for other things, but I'm going to focus on medical and psychiatric. This allows the principal to state their wishes or appoint someone on their behalf if they can't communicate how they would like life-sustaining treatment to occur if the situation arises. It does also allow them to appoint a healthcare agent to make that decision based on the previously expressed preferences. That was awful wordy. But there's different types of advanced directives. First would be a living will, and that is something as a person going into the hospital, if I'm going to have surgery, I may say, I want to have some life-sustaining measures, but not all. I would want CPR, but I don't want to be on a feeding tube, or I don't want to be on a respirator. This is what a living will declaration allows the individual to do. Do not resuscitate is an advanced directive as well. And that just means there's really no heroic measures to be instituted to sustain life. A DPOA is actually another type of advanced directive. And DPOAs may include end-of-life decisions in addition to those other matters of the principal's life affairs. I bring those up because I think in healthcare, particularly for psychiatric services, thinking about what happens if the road to my recovery gets a little rocky. What would I want to have happen, or what would family and I agree needs to happen if I get to the point where I can't communicate those preferences? And I think it's also very important because there are so many options for individuals. So like DPOAs or POAs, advanced directives must be written. There's typically requirement for signatures of the individual, witnesses requirements. There's specific information that's required about the content that go everywhere from the type of care to religious preference to pain management, organ donations included. Advanced directives like DPOAs and POAs should be reviewed regularly. There should be a revocation piece involved in there, and understood that that can be revoked at any time. And with advanced directives in particular, they can be revoked verbally at any time. And then with these types of documents, distribution is real important. So ensuring that the advanced directive, a POA or DPOA, is accessible and provided to the agent and any healthcare providers that may need to know. Like, for example, at the mental health center, we would want a copy of the advanced directive or DPOA. We would also want a copy of that guardianship. So as the provider, we can make sure that we're consistent with the agent or the guardian's preferences, as well as the ward/principals, what their preferences are. Other requirement under advanced directive and DPOAs is that the party must be at least 18-year-old. And there is a pregnancy clause. There is something in Kansas that says a living will or DPOA for healthcare instruction to withhold life support is not effective if the patient is pregnant. Now, disclaimer there, that's an area I'm not real versed in. I just noticed it when I was doing a little bit of research for this presentation. So I would encourage you, again, seek outside counsel when you get there. So after all that information, how do we decide as a family what is the best route to go? I think there's room for all different types of POA, DPOA, and guardianship, and I think they all exist for different reasons. And making that decision is extremely personal to the individual affected and the person that's going to be helping. My best suggestion is first, have the conversations before a psychiatric crisis or medical crisis occurs. Talk to my family member. Let's have a conversation about if things go bad, what do you want to have happen for you? And how can I be of assistance to that? It really is a conversation and a collaboration between the individual and the family member or sibling or whatever that's going to be helping out. And it's important to remember that first and foremost, the principal award is kind of in the driver's seat to some extent. I mean, obviously, with a guardianship, there's some piece there that the individual does lack capacity, but they still have a voice in what decisions are made on their behalf. And that's important to honor and make room for that regardless of the method chosen, a guardianship, power of attorney, advance directive, those are conversations that need to be had regularly. Some require to be done at least annually, like a guardianship that is looked at annually by the court, and continually discuss and look at the parameters that we've outlined either in that document or in our POA about what is working for that individual now. When those documents are effectuated, it's important to disseminate them to providers and being transparent with one another about what's in there. And again, absent of the guardianship papers that are legally binding and set up a different way, the POAs and advanced directives may ebb and change and flow based on where the individual is at in their recovery journey. I've got a few resources here that I can share with Kelly. At this point, I'm going to stop sharing my slide and see if there's anything, Kelly, I missed that you want to talk about now.
No, Christine, thank you. This was wonderful and I think incredibly helpful. And what I like about it is it really does protect the voice of the individual needing the a little extra help. And it gives that
Mhm.
family member just the okay to move forward with their plan. So I think you did a great job explaining it. I know this is going to be incredibly helpful to a number of people. And so I want to thank you so much
Thank
for
you.
your time and we appreciate you. And I will put those links in the description of the video. So they'll be able to click on those and access those links. But thank you so much, Christine.
Great.
Really appreciate it.
Well, thank you. And I've appreciated the opportunity and I wish all of your folks the best of luck. And again, reach out, ask the questions. There's lots of us out in the field to help work through processes. Thank you
Thank
again.
you.